Welcome to the Florida Appeals Journal. I'm Jennifer Carroll, and this week we're going to talk about a misunderstood issue in the law and among litigators, and has to do about striking pleadings, motions to strike pleadings. Very little understood rule in the Florida Rules of Civil Procedure. And is it really a different animal? Lawyers know you have pleadings, your complaint, answer, affirmative defenses, and oftentimes you need to move to dismiss, move for a more definite statement, move for clarification. But motion to strike, how and when to use it. Essentially, there are two ways to go about striking pleadings. And I'm going to cite the two rules of civil procedure here in Florida. You've got 1.140 sub F, and you have 1.150. And 1.150 is also known as the Sham Pleading Rule. And let me just briefly talk about 1.140 F. That's, you're going to use that when you need to strike redundant, immaterial, impertinent, or scandalous matter from any pleading at any time. So that can be filed at any time. And unfortunately, the way litigation is today, you've got attorneys and their clients putting in matters that need not be there, and they're totally irrelevant. And they have ulterior purposes for putting those in the pleading. So you really want to be on the ball and catch that definitely and do something about it. So that's when you would do the 1.140 F, and you would move to strike that. Now let's just talk, we're going to focus on rule 1.150, which is known as the Sham Pleadings Rule. And let me just quote for you the Supreme Court case that really defined a sham pleading as one, quote, is palpably or inherently false, and from the plain or conceded facts in the case must have been known to the party interposing it to be untrue. So what does that mean? You have a lot of cases that try to explain that. A few things you have to know when you're going to use that rule. And you think, I've seen it used when a litigant may be thinking that the other party is trying to perpetuate a fraud on the court. I've seen them tie it into motions to dismiss, motions for summary judgment, all encompassing a motion for sham pleading. And it gets very confusing because it affects the standards that the trial court is supposed to be using. So let's step back. First of all, the power of the court. We all know the court has the inherent power to address frauds that it feels are being perpetuated in a case by a counsel and their client. So there's inherent authority to prevent an abuse of the processes of the trial court. Now, when you do a motion to strike, remember, you've got to comply with certain procedural components of the rule. First is you've got to have it verified. Otherwise, you can go to all the trouble, and then on appeal, they find it's not verified, it's going to go back down. Also, the trial court is required to have an evidentiary hearing on a motion to strike. So you always want to follow up with that rule. But some of the principles I think you need to be well aware of with respect to motions to strike. Okay, remember these general standards. A sham pleading is one good on its face, but absolutely false in fact. So that's what your evidentiary hearing is going to be establishing, is that it is false in fact. And you really have to show that to the court by a clear and convincing evidence standard. So it's a very high burden, of course. And the motion to strike a pleading has to be tested by the same standards as a motion for summary judgment. And again, quote, for a trial court to strike a pleading as a sham, the falsity of the pleading must clearly and indisputably appear. I'm going to cite you to the Bornstein case, Bornstein EIN, and that's 169 Southern 3rd, 1239, and that's a 4th DCA case, 2015, and just lays out some basic principles. So for a trial court to strike a pleading as a sham, it must evidently be a mere pretense setup in bad faith and without color of fact. So you got to show the other party is operating in bad faith. But remember the standards, and similar to summary judgment, when the trial court does review it, all doubts have to be resolved in favor of the pleading. Okay, the court's policy dictates litigating cases on the merits, and they want to uphold that pleading if at all possible. And remember, a motion to strike a pleading admits the truth of all the facts well pled. I'm always surprised at that, but it still operates in this context. I'm going to cite you the first case, FURST, and that's 819 Southern 2nd 222, 4th DCA 2002. So these are a couple what I thought are some really good cases on the issue, and lays out some of the rules that you're going to have to follow on the motion to strike. But the tip of the week with respect to this issue on doing a motion to strike is you really you have to, of course, think about it and think about what's your strategy, and make sure you're following the right procedural path. Because remember, you do a motion to dismiss, you are bound by the four corners of the pleading. So you can't really bring out any extraneous material for the court to consider. Okay, so you're going to be bound by that. So you may not want to do the motion to dismiss. You do the motion to strike, and really with the motion to strike, evidentiary hearing, you can do a request, take judicial notice, and bring out some extraneous material. And like I said, I've seen it in conjunction with the motion for summary judgment, but I think the timing is very important on that. And a summary judgment is going to, I think, take longer. I think you have other rules at play. What discovery has been done. It's that, as you know, involves many other different procedural considerations. So for this week, I would refer you to those cases. And I do want to say also the standards of review. When I talk about if it's motion to dismiss, if you tie it into motion to strike the pleadings, motion to dismiss on appeal is going to be governed by a de novo standard of review, which the appellate court reviews it in the first instance and doesn't have to give deference to the trial judge. But now if it's a pure motion to strike as a sham and you're reviewing an order granting that, you're going to use an abuse of discretion standard for that. So keep that in mind also when you're selecting your strategy with respect to doing a motion to strike on the opposing party's pleadings. Thank you so much for your time, and keep us posted on any issues that you would like to have heard or addressed in future journal entries. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below so you won't miss a single one.